Good afternoon, good morning, good evening, good night, depending on what part of the country you're located at. This is Jasir Jamal from Texas 1031 Exchanges, located down south of the country, of course. So today I want to go ahead and talk about this real quick before we start the video, which is that, look, every single thing I have said in my video, and I will continue to say in my future videos, including this one, every single thing I say is meant for educational and informational purposes only. Please do not consider or construe anything I say in these videos as legal or investment advice, because it is not legal or investment advice. Please, every time you folks decide to do a 1031 exchange, or even if you don't, you just make an investment decision, please always do your own due diligence and always consult with your own CPA, your own tax attorney, or your own estate attorney before making any big investments like these, any big major investment decisions like these. So here's the thing, investments have risk. You are never guaranteed to make money. There's a possibility that you can also lose money, which is why it's always important you do your own due diligence and consult with your tax attorney, CPA, and estate attorney before you make any major decisions. So without further ado, let's get into the video. So by far, you folks are very well aware of the fact that when you decide to do a 1031 exchange, you need to have held your investment property for like a certain amount of time. I mean, my rule of thumb I've mentioned in all my videos is 2 years, and you folks know why. And as I've mentioned before in one of my other videos, that it doesn't say exactly how long you need to hold the property for in the Internal Revenue Code, but 2 years is what a lot of legal and legal experts and a lot of CPAs usually recommend. But then again, when it comes down to that, I mean, you could do it within less than 2 years. You could do it after holding it for a year. It would really depend on your financial situation, and that's why I always say you should talk to your CPA or your tax attorney before making those decisions, because they understand your financial situation way more than I personally would, or any of my CPAs or tax attorneys would, you know? So therefore, it's always best to do that. But in my previous video, when I read out an entire letter that was issued from the IRS back about a long time ago, they basically said that, look, a property that you decide to 1031 exchange into, and if that replacement property is held for immediate sale, remember those keywords right there, then the IRS is most likely going to invalidate your exchange. And immediate sale basically ties into the word flipping, basically. The IRS doesn't say what exactly does the word immediate mean, how much time is immediate to them. So, of course, based on that, every last one of us can feel comfortable saying that, look, if you decide to do a flip with your property, the IRS is most likely not going to like it. You have that. So if I were you, I would definitely avoid doing flips with your, like you just sold your relinquished property and you just did a 1031 exchange into a bigger replacement property. Try to avoid doing a flip with that, because most likely the IRS is going to challenge it and it's not worth it. But here's the most important thing. I've mentioned in my previous videos as well that it's all about your intent. The IRS wants to see your intent. But now today I just want to dig down a little more into there, and I want to offer some opinions on that, and then you folks can go ahead and make your determination from there. So let's go ahead and talk about it. The board is nice and clean, so let's put that down and let's come over here. So basically, the IRS is looking at your bona fide intent. That's just a fancier way of saying they just want to look at what your intentions are with the replacement property. So here's how they determine it. So let's say, for example, you just sold your relinquished property, you just 1031 exchanged into your replacement property, and by far your plans have been, let me actually draw this out for you folks. Here's your relinquished property, this small house, and now you're just buying this huge piece of raw land because you're going to develop some more, what do you want to say? Let's just say that you're going to develop a gas station on there just for the sake of this example. No problem. Here, here, and here. So by far, okay, you sold this house and you 1031 exchanged into this huge piece of raw land, and you're going to go ahead and build a gas station on there. And by far, your intentions is to hold it for investment or to develop it into a gas station. Sure. And let's just also say that you went ahead and you got the permits approved to build a gas station. Like here in Texas, you need a TABC license, of course, in order to build a gas station, because you're going to sell liquor in there, most likely, or alcohol. So you have your TABC permits ready. You're going to need, you're going to look at your IMST report to see if this location is actually at this location, if there's a gas station here, is it actually going to be profitable? Of course. And of course, you're probably going to get the property platted if it's not already platted. And what else? You're probably going to get some permits from the city and county. Let's just say city and county permits right over here. So you're probably going to get all these things in order to develop a gas station. And if any person were to look at this, even if the IRS were to just look at these right over here after you just did a 1031 exchange, it's pretty clear that your intentions are to develop a gas station and you're moving forward with it and all the plans are approved and you're ready to go, you know? But now let's say all of a sudden this random gentleman comes over here. This random gentleman just comes up. Let's say you bought this gas station for $6 million. I'm sorry, no, not gas station, this raw land for $6 million. This gentleman comes up here and he offers you $8 million. Of course, he offers to buy you out, buy this land from you for $8 million instantly. And there you go. You decide to take that offer because it just looks so good, you know. And next thing you know, you just end up selling it. And there you go. There you go. And you held this property. You just did a 1031 exchange into it, and you didn't even hold it for that amount of time. And this gentleman just comes up, buys it from you for about $8 million. You just made $2 million in profit. Then will you have issues then? Well, now, as I've mentioned, it's about your bona fide intent. Easily, if the IRS does have a suspicion about this, and if they do decide to challenge your exchange, but there are chances they won't, because look, if they do, you just have to show them all your emails, all your paperwork, which either you can give it to them or the IRS is going to get it from you in a subpoena. And of course, you have to show them that, look, you obtained your TABC permit, you ran your IMST report before you started anything at the location, you platted the property, and you got your city and county permits approved, and you were ready to go. And then you can tell the IRS, this gentleman just came through randomly and he decided to buy it from me, and I decided to give it to him because at the end of the day, we all want a deal, you know? Then most likely the IRS is probably not going to challenge your 1031 exchange after this. Because look, your intention, you show all of this to them, your intention looks like you wanted to develop this and use it for investment purposes. And then the IRS, when they see that, and when you can prove it to them, they will probably let you go without any issues. But this is only going to happen, you're going to have to show all this proof to the IRS if they challenge your exchange. But there are times like, look, this gentleman just bought it from you and it's been like less than 6 months since you 1031 exchange into the land. And next thing you know, you file your taxes, you file your Form 8824 at the end of the year. And then on your taxes, you show that you ended up selling this after you did a 1031 exchange onto it. Then, I mean, the IRS usually has like about 2 through 3 years to go ahead and challenge your 1031 exchange, specifically this one if they want to. And they will usually keep your file open for that long. And if you don't hear anything from the IRS within the next 2 or 3 years, this means they probably just did not even bother and they figured out that you wanted to use it for investment. But if they did, chances are, based on what I know from my CPAs and from my tax attorneys, they will most likely say something to you within that 2 to 3 year period, and then they will probably challenge your exchange, and then you will have to show them all this proof in order to, you know, defend yourself in a federal tax court if they decide to take it in that direction, you know. But then again, they can always let it go because they probably understand your intent when they just look at your taxes, and that's pretty much it. So here's the thing, like I've mentioned before, there's no specific amount of time you need to hold that property for. We read the revenue procedure letter the other day, and the IRS doesn't like it when you flip your replacement property. They will definitely challenge that. But if you were clearly, you know, gonna go ahead and use it for investment purposes, and somehow a random deal just came in front of you, and next thing you know, you just ended up taking it because it was just too good, then if you can show all this to the IRS, if they challenge it, then you should be fine. You'll be good to go. But then again, I mean, you folks need to think about this. Like, you can definitely have your intentions to hold that property for investment purposes and everything, but at the end of the day, do you really want to, spend all that money on tax attorney fees and accounting fees when the IRS were to challenge your exchange, and just to prove to them using all of this that your intent was to develop it? Because here's the thing, if the IRS does challenge it, if you win, the IRS is just going to get off your back. You won't win any damages most likely, or at least it's going to be very tough to. So that's where you folks have to really think that, do you really want to take this risk of just immediately selling that property and next thing you know, the IRS challenging it, and then you're going to spend all that money just to prove to them that that wasn't your intent. That's where you folks need to realize it, that is it worth it or not? For some people it is, for some people it is not. But at the end of the day, you folks know my opinion on this. It's best that you folks shouldn't do anything like that. You folks should definitely not do flips with your replacement property. Try to hold it for at least 2 years. And of course, try to get some cash flow out of it just to show that that was your intention. And then from there on out, you folks can just go ahead and move from there. But I know I've made a lot of videos with regards to all of this, but I really hope all 3 of these videos, when you folks watch them, then you folks will get a better perspective about how to go about the 2-year period. So with all this knowledge, you folks will be able to make better decisions with regards to what you want to do with your replacement property after you just 1031 exchanged into it, you know. So anyways, folks, that's it for me today. If you folks have any more questions regarding this topic, please feel free to reach out to me. Until then, I will see y'all in the next video.